everybody. Welcome to today's live stream. The esteemed guest today is Professor Joe Potuto. Thank you, Professor, for being here again.
Thank you for having me again.
Sure. We're waiting for attorney Katie Bogenschutz to join us. She should come within the next few minutes. Yeah, but why don't we go ahead and just share our quick thoughts about the Lori Vallow Daybell guilty verdict?
You're asking me?
Yes. So
it was no surprise.
Same.
I mean, there was, and I like the way that the prosecutor to do things out of order because Lori either claimed or feigned or actually was ill at one point, so they had to reorder the witnesses. And I think I heard a juror interviewed and he said it was, disjointed and they were having trouble following it. But that aside, because the prosecutor couldn't control that, I thought she did a really nice job. And I thought, you hear commentators say it's conspiracy and they're not showing conspiracy, they're just showing a murder. You have to wait until the state finishes its case to know. And I thought the order they did it in made a lot of sense. First, they went ahead and showed the attempt to shoot and kill the victim. And they tied all those little bows and got that done. And then they went into evidence showing her participation in the conspiracy. And that's what they ended with, her participation. So I thought they did it just fine. I thought her closing was really, did you see her closing, Judy? It was great.
Yes, I
It
did.
really
Yeah.
was great.
Yeah, and wasn't it surprising how quick this whole trial was? It seemed to just start last week, wasn't it?
Lori didn't know how to cross-examine witnesses, and she didn't cross-examine some of them. The detective that she didn't want to testify at all, as I recall, she then didn't cross-examine. So that certainly shortened it. I mean, she doesn't know what things she can object to, and it's objections and sidebars that, also tend to lengthen the time of a trial, and she wasn't doing that either. So I guess I'm not, given how she did it, I'm not surprised that, it went as fast, and I wasn't surprised that the jury didn't take very long either.
Yeah, wasn't it 20 to 30 minutes of deliberations?
It seemed like it was less than an hour. Yeah.
Yeah.
Well,
So
and she, excuse me, she cross-examined on things that were just, was the van or the car, whatever that car was it green or was it gray? And of course, the prosecutor in closing said, "What difference does it make? We know it was that car. It's a car with Texas plates. We have all this evidence showing it." So I just think she didn't have she didn't have a good idea of what she was supposed to do. I shouldn't say either. Didn't have a good idea of what she was supposed to do. Had a good idea and wasn't able to do it. Got flustered when there were objections as to how she was asking the questions and dropped lines of questions, questioning because of it. Or just had her own idea of what was going to succeed and nothing. I assume the lawyers that were assigned to assist her tried to advise her, and the final option is that she thought she knew better, and clearly she didn't.
yeah. So it does make for some great comedy. But do you happen to know how it worked with those advisors who were supposed to help her?
Yeah,
Like, did she keep going back and forth to get help?
When you go pro se, you have no constitutional right to have a lawyer advisor help you. And if you recall, what was it was don't remember which one, when they were going to go pro se, they didn't get advisors. The advisors are there if the pro se wants to use them or seek advice or counsel. They're not supposed to initiate because the pro se defendant is the lawyer. So it has to come from the pro se defendant to them. The theory with them is if it crashes and the pro se defendant is doing a really bad job and says, "I can't," that they can step in. But I think that's only in theory because you've got a jury who's watching it, and all of a sudden the defendant is no longer handling the case, and they're going to have a lot of questions about it. Plus, you're asking those lawyers to come in and intervene in a case that was probably presented in a way they never would have presented it. So, but that's the theory. They're there if the defendant wants their help. It's in the discretion of the judge whether to provide them or not. The defendant has to seek the help. It can't go the other way. And the theory is that if, what looked like it might happen in Daybell, which was she was saying the last couple of days of trial that she was too sick to come, and the judge issued an order saying, get her here by force if necessary. So if she had refused to do anything, the theory is then they could step in. But as I say, I don't know that the theory would play out very well in practice, but I hope that's responsive, but that's what they do.
Okay. Yeah. So of course she made this horrible closing argument where she just kept trying to talk about her feelings and what a good person she is or something. So it just seemed like everything was objection.
Yeah.
I'm going to go ahead and object right here. Sustained. So
Yeah.
that was kind of funny. Yeah.
It was, but it's frustrating for the prosecution because you're getting the objections, but she's still getting in some of that information. I mean, no matter how many times, and the jury doesn't know why the prosecutor is objecting, because the prosecutor can't say it's because she's not some sweet, loving family person. She killed, 3 other people, and they can't say it because the judge let them get in that there were other investigations involving her, but wouldn't let them say it was murders, because once you put that in, I don't care what jury it is. If you tell anybody on a jury, this person killed 3 other people, including 2 of her kids, you have lost the defendant has lost any opportunity to get the jury to say, gee, in this case, even though it's related, it's the same sort of, general plan, that this time she didn't do it, or this time there's reasonable doubt. So the judge, there were many times when he could, based on the way the law works, that he could have done it clearly, and he just did not want to go that way because they would have had the chances of being reversed on appeal were not negligible. Hi,
Right.
Katie.
Hi, Katie. Thank you for
Good to
joining
see
us.
you guys.
Yeah, it's so last minute that I had to quickly change the thumbnail and add in a picture of Katie's face to the thumbnail. So thank you so much for being here. How was your day, Katie?
Ed, I did some filming for Law and Crime, so I was just catching up on the Donna stuff because it was scheduled at the same time, and yikes.
Mm-hmm. So what was it like being on Law and Crime?
I have no idea. There was just somebody filming me in my office, so he was nice though. I liked him.
Great. So they have a big budget then, if they could send someone out to you?
Yeah, I was really surprised about that, but I think they're trying to get into doing these kinds of documentaries type, like short documentaries on higher profile cases. So I said yes, and we'll see if I regret it.
I'm sure you said a lot of good things. Yeah, I mean, did you want to say anything briefly about the Lori Vallow Daybell trial?
So I haven't been watching this recent trial, but the last trial I did watch a significant amount, and she was not doing terrible. At least as far as I expected a dumpster fire, like a nuclear dumpster fire with her pro se representation. And it was, a small, it was like a small kitchen fire. It was something you could put out with one of those blankets. Well, she was not doing a terrible job, but she's had plenty of other lawyers to learn from in all of her other convictions. So I don't know if that's really something she should brag about.
Well, in this trial, she came closer to what you would have expected her to do.
Oh, the dumpster fire. So I need to watch it.
Acting up, but not necessarily in front of the jury, but she started out saying she was ill and couldn't do the trial and had to stay in her cell and didn't want to come to court, and he had to have an independent physician. The judge had to have an independent physician examine her and decide that she could do it. And then she spent, we were just talking about that, every time she could, trying to get in the good character evidence, consistently, testifying about things. And then the last couple of days, she sent one letter that said the judge, she was afraid of the judge.
Oh my
She
God.
tried several times to get him removed from the case. And then I guess in the last 2 days, there was another letter that she sent asking to have another judge disqualify the judge who refused to disqualify the trial judge because he was biased also. And then refused to come to court. And they had to go get her, and the judge's order was by force if necessary. And she came to court. So there was a lot more drama this time around.
All necessary force.
Yeah, that's right.
Yeah. Love that. I love
Yeah.
that for her.
Yeah, but as Professor Potuto and I were just talking about before the show, this is why I think the Markel Adelson case is so much more captivating to me, because, with Lori Vallow Daybell and those people out there, as Kathy would say, Idaho, or wherever that is out west, you just feel detached from them. These are people that we don't identify with because she's crazy. She's like a nutcase. And so it's like, okay, well, she's just like your typical criminal who's like mentally ill and delusional and stuff. Whereas with the Adelson case, I feel like I identify more with it because you have these people in the legal field, people who are educated, and they seem like people we would run into. So, I mean, do you guys feel like that too, that you're more into the Markel case?
I certainly think that she's not way out there the way Daybell is, or Sarah Boone, same thing, writing letters all the time and, saying what, 9 lawyers, at least 5 of them, her claims didn't seem to have much to back them up about a lawyer. Donna is, I guess, more controlled than that, but she also does, she can't not talk. I mean, no reasonable person would chat away to the people she chats to when when you're being taped, when it's not a privileged conversation, so you're right. She's closer to what we are, and she seems to be somebody closer to the people we might run into, I think. But I don't know how Daybell presents, when she's trying to make an impression. Whether she can go for a while and seem perfectly normal to the people she's dealing with until she's not.
Some of her prior, like when she was on a game show, and she was also like Mrs. something pageant. She was in some pageant, and I mean, she was quite charming when she was
Lori?
talking into the that's the game show aspect of all this, because obviously, mischief maker and I think both Wendi and Donna were on game shows. But yeah, it's one of the forensic psychologists that I used to talk to quite frequently about my cases, not about myself, obviously. But he said, what's the interesting thing about some of these cases is the banality of evil. Mm-hmm. That, when it's a lot more like us, it's a lot more interesting, because hidden in that is the question of, could I be that given the right scenario? And who am I close to who could be like that I'm unaware of?
So did both of you have time to watch today's hearing?
I did.
I got through the testimony. I have not made it through the final portion of the argument. Let's see. Yeah, I've got about 15 minutes left.
Oh,
I got through the whole thing, start to finish, gavel to gavel.
Right. You were on Surviving the Survivors.
Yeah, and I commented on it. So
yeah. Okay, so Professor Potuto, can you give us the cliff notes of what happened then, since you were there?
My summary of the expert was he was unpersuasive. Katie, well, you heard some of his testimony. You said you heard the testimony. He was talking about, I forget the word he used for it, how many newspaper articles there were, how many broadcasts there were, but no demonstration that any particular person watched them or watched them all the way through. And he ended up giving away the game because he was asked, wouldn't it be helpful to know, if a particular potential juror actually read one of these articles or saw it, and he said something like, of course. Well, that says you're going to have to try to sit the jury, because how else are you going to know? Because the data he was presenting, there are a lot of this, there's a lot out there, but he wasn't able to tie it in any particularly good way to the issue of the jurors in that might be sitting in this case. So that's my thumbnail. My other part of the thumbnail was, and I said that on STS, I think they would have been better not to use him at all and then have Josh make the argument he made, which I also didn't think was strong, but at least, it seemed to me was closer to the type argument you have to make. So that's 2. And 3, this motion was premature. The judge is going to reserve on it. He has to, because when you get to trying to sit the jury, if you can't sit the jury, you're going to have to change venue. So, I mean, that's obvious. So the cases that Zellman was citing, he had one from 1950, and I don't think it's been cited in the last 40 years. So it hasn't been overruled, but it hasn't been used either.
Yeah.
But the cases that he was citing and the law he was using, some of it anyway, was perfectly correct. If you don't know whether you've got an unbiased jury, you've got to go with the defendant. That's perfectly correct. But the timing is wrong. You don't do that now. You do it after you try to sit the jury. So that's my thumbnail.
And Tallahassee is a big turnover town because it's a college town. And then, as different administrations get through the governor's office,
Right.
People move to town and join agencies. People go to state agencies right out of college, and then they move on to private industry. I mean, there's a lot of turnover in this town. And the great thing about government workers is they're all good little rule followers. So if a judge orders them to disregard anything they've read, it's really interesting. Most of them will say, okay, I can do that.
And that's another thing. This expert, whatever they do, they don't do trials. Most of the time it's PR, it's marketing or whatever. He didn't tailor the group that he was looking at to this case, because he's looking at census figures for Leon County. Students typically list their permanent residence wherever they live, so you're undercounting them. He should have looked at, if it's registered voters you use, that's the group cohort you should be looking at, and he wasn't looking at it. So a lot of experts do that, at least the ones that I used to see on the academic side. They're on the circuit, and they'll come in and talk to your group, but your group may be different, and they don't take the time to tailor and look at the differences in your group. And it was obvious when he was testifying what he didn't know about the juries. And then, Katie, if you were there, you heard that first question, how much you're being paid, and he claimed not to know.
Right. Well, that was when I just kind of shook my head and went, you've got to be kidding me.
Yeah, he was playing dumb because he's probably still billing for all his time.
$1,500 a month and $4,000 for him to testify. I'm like, no.
Right.
Because there's going to be prep time. There's going to be.
Right. Plus, he had to have been told by you would think, by defense counsel, that's going to be the first question you're going to be asked. So if they didn't tell him, it was bad prep. And if they did tell him, he should have had that information. Certainly the prosecution is entitled to it.
Yeah, and I also feel that and this is my 2 cents, and Georgia kind of touched on it, that 15 years ago, like back when I graduated law school, and there was like less of the internet presence of internet like type cult following type things, that was a much better argument to make. But now you could be just as into this case and live in Arlington, Virginia, or Boston, or, I mean, because you choose the media you consume.
Right.
And, you know, the algorithm feeds you what it thinks you want. And by clicking on something, it feeds you more of it. So it really, like, I mean, you kind of self-select as to people who listen to it, and then people who don't want to listen to it don't.
Yeah, and Jared Ross in the chat this morning said something that I'd been thinking about, which is right. If you take that argument to its logical conclusion, you can't sit a jury in a high-profile case.
Period.
Period. Yeah.
Right. And that's not going to be the case. Now, probably the most famous case of a change of venue in the Tallahassee area is Ted Bundy, if you'll recall. And that was put down to Miami. My mother was a prosecutor in Broward at the time and kept telling me how handsome he was. It was very disconcerting. But so I guess she was a groupie, even though she was a prosecutor. But that was, you know, it was multiple deaths. It was the entire area. I mean, first of all, significantly smaller area, significantly smaller population, high profile deaths on campus. He also had those high profile murders out west, most of which he was not tried for or even charged with. So, and then he killed that little girl in Lake City.
Yeah.
And then he's running from the Pensacola police and begging them to shoot him. So he kind of made it for himself, and it was transferred to Miami. But I mean, like, there was a lot going on there.
He also had two high-profile escapes while he was being held in custody. I mean, yeah, he was a media phenomenon.
And he kind of enjoyed it, I think.
Yeah, of course he did.
You know, there's an elevator in the courthouse that I found out later has been referred to as the Bundy elevator, because that's the elevator they used on him when he was in court here. And I think it was because of its security, you know, given his prior escapes. And the sheriff of Leon County at the time, or maybe it was Pensacola, I forget, he had a real deep Southern accent. He said, "I told that Colorado man he could have Mr. Bundy when I was finished with Mr. Bundy." He's already escaped from your jail twice, essentially.
Oh, that's a good accent.
Yeah, it was. I remember laughing out loud when I heard that. It was great. So, I mean, but he was his own breed. I mean, he's kind of like the gold standard serial killer, and I really don't think Donna falls into that category.
No.
Well, we're getting some questions already here. Thank you guys for being here. I don't know if we know the answer to this question. What type of info or evidence was provided to get the latest wiretap? Was it on Harvey's phone? Oh,
well,
isn't
provided to get the wiretap? We know a little of it. We know that there was some informer. We think it was a jail informer who must have gone to the state initially and provided some information. And then the evidence they had, because the first warrant was not the wiretap, the first warrant was simply, you know, you're going to find out what the list is of phone calls that Harvey made. From that list of phone calls, they're going to see phone calls to the phone numbers of the lawyers for Donna. And then they ask for the pen register and the trap and trace, which then can triangulate what numbers are coming from the lawyers to Harvey, what calls are going from Harvey to the lawyers. And then they had the jail record showing that the lawyers were at the jail for some of those calls. So they had all that evidence when they went for the wiretap. They may well have had other evidence, but we at least know they had that much.
Oh, thank
you.
And
we might find out more as we move along.
Right.
Because they said that they don't, or I think Sarah said that she doesn't think that maybe one or two would be used in trial. So we'll probably get a little bit more evidence as to what they were actually targeting once that's actually put on evidence. And keep in mind, it could also be rebuttal,
right,
that they end up collecting that they may use against her if she takes the stand. And I just can't imagine. She's going to be a nightmare on the stand.
Yeah. Mm-hmm. Which, by the way, is another issue that Lori Daybell had at her trial. Mm-hmm. She couldn't understand that even though the state said if they were not going to try to use the evidence of the other crimes, that if she kept introducing character evidence, that they were now saying they wanted to use it. She could not get it through her head that once she started introducing things, the calculus changes and the prosecutor is entitled to try. And they went through that over and over and over again. It was like a broken record, the number of times that the judge tried to get her to understand.
Yeah, it's something called opening the door.
Right.
Yeah.
That, if they agree they're keeping it out, but you try to introduce evidence that is completely contrary to that, then they have a right to rebut that if you're, to avoid giving the jury a false idea of exactly who you are.
Right.
Mhm.
She could not
Exactly.
understand that. Could not understand that.
Mhm.
Uh,
Yeah. So it's sort of like if Donna started talking about how much she loved Dan and respected him, and there really wasn't a problem between him and Wendi before he was killed, or between her and
well, she was
him.
making banana bread, wasn't she?
Yeah, and
Yeah.
gave him a
Donna
hug.
yeah.
Can you picture her baking? Because I can't.
Yeah.
It doesn't seem like the type.
Yeah, I don't think so. It might ruin her figure.
Right. No, that's what I was thinking about it. There's a lot of carbs in that. I mean, I
Well,
love it.
baking it doesn't ruin your figure. It's eating it that ruins
Eat
your
it, though.
figure.
That's a good point.
At least as I understand the way calories work.
Yeah. Well, but what about this question? Thank you, Tennis Girl. Is the trial delay hanging in the balance? I think it's going to go forward. What do you two think?
I think there's room for it to be delayed, but I think that Judge Everett is losing his patience with delays. I mean, there's already been 2 false starts here. So
And they've
there
already
better
gotten
be a
at
damn
least
good reason.
they already have gotten at least one continuance based on the 100,000 emails or information from the wiretap. I don't know that we know how much was maybe phone calls and how much was emails that they got late, because that was the taint prosecutor who had looked at those and did not turn them over to the state because he determined that they might be privileged. And Donna's lawyers got them late, and they keep saying it's like a little chant that they use. It's a Greek chorus: 100,000 emails, 100,000 emails. So that delayed it. I think at this point, because they were making noises about maybe needing more time again, and Judge Everett said, let me hear. I think at this point, they're going to have to show either it's based on new evidence that's only come forward, or in the exercise of due diligence, they couldn't have worked any faster on what they have. And the guy's going to have to make a showing. They do a good job of asserting things without ever bringing in any evidence to support. It's pretty interesting to me, because those obviously are bad arguments when you do it that way. So they're going to have to show it. The other thing that might, who knows, they're saying that based on what they're finding from those emails, they have to depose other people, and they found things that might potentially be exculpatory. So to the extent that's true and they could make that showing, obviously they have to be given the time to do that. And then sitting, as Donna's motion to have Judge Everett recused. I think even if he recused, I don't think that would slow the trial down. But I suppose the next motion they'll make, I don't think that will happen, by the way, but were it to happen, it seems to me the next motion will be, he ruled on some things, and we
And we
know
need
that
to do it again.
so now we need to redo them. Yeah.
Well,
That's
that
right.
ends up becoming what's called the law of the case, doesn't it, though?
Right. Yeah.
And you're not going to get it reheard.
Well,
unless-
Katie, except that if it's true he had a conflict when he ruled on them, then that will open the, I don't want to say open the door again, but it will, because you can't rely on a decision made by a judge that you have concluded had a conflict and shouldn't have been hearing it in the first place. Because if the conflict exists, that may have affected the decision. One of the motions, for example, the bond motion,
that would have been done after the
after, And they say that Judge Everett at the bond, well, he did say this at the bond hearing. I don't know, something along the lines of, I don't know why you need more time because you've been meeting regularly with your client all along. They say the only way he would know that is because he had looked at the information in the affidavit and application for the first two warrants. He didn't do the wiretap warrant. And therefore, so they may have, assuming that, I don't think he's going to be recused, but assuming that that's the decision, there may be hearings on motions well, I'm sure the defense will make it, but there may be one where you're going to have to do it again because the conflict of the information he had that he shouldn't have had in order to rule. And I assume you would, as a defense lawyer, they were at a hearing blind because they did not know that the prosecutor had other information, if it was relevant to the particular hearing. And so, well, I'm making a lot of assumptions here, but if there's one where it was relevant to the hearing and they didn't have a chance to confront it or rebut it, and there's a decision that the judge had a conflict, then you can't have law of the case. But otherwise, you're right. Law of the case would control
I
on
guess it
all
would
of
be
that.
in effect since about February then. Yeah,
Yeah,
everything since
yeah.
February potentially,
Right,
or
right.
whenever that
Right.
went through.
And I don't know that there was anything of substance that happened,
Yeah,
The
but
only one
I think the bond motion was probably the only thing, and
I
then
think it is,
and
but
then this hearing.
yeah. And the bond hearing would be easy to fix. You have another bond hearing because I looked at the decision on the bond hearing, and Everett based it almost exclusively on the fact that she was trying to get out of the country.
Yeah,
In the conclusion, he made some reference to she's also had the chance to talk to the lawyers, but that was based on, the trying to flee. So if
yeah.
they
The
have
most
another bond
important
hearing, you're going to
part
get
of
to the same place.
the most important thing with a bond or with pretrial detention is that the person that is going to be on trial returns for the trial.
Right.
And then it's safety of the community, and then it's potentially spoliation of evidence and all those things. Being arrested at the Miami airport, I mean, I get why they asked, but surely nobody thought that was going to be granted.
Yeah.
Surely.
Right.
Yeah, that's right.
Right.
Well, Zellman said that he plans to file at least one more motion next week. So, Katie, does that mean there's going to be another hearing? I mean, every time there's a motion, is there going to be a court hearing, or do some of the motions get ruled on without a hearing?
Well, it depends on what the motion is, and it depends on whether somebody might need to elicit testimony or be permitted to have oral argument. I get the feeling that Judge Everett is on the dot your I's and cross your T's train. With this case, it's a first-degree murder case. You don't just rule on motions in your chambers on cases that are this serious. I mean, if you were to file a ridiculous motion in a coke case, I think that he might, just slap you on the wrist from his chambers. But the reason this kind of a record is being made is for an appellate attorney in case of conviction. And you watch yourself in these cases and you are extra careful, and you should be seeing the state attorney's office going, watch my hands the whole time. If you think that they're being extra careful, they are.
Sure.
Okay. Katie, maybe you can answer this question. So would they remove her ponytail holder because she could use it to strangle herself or choke herself or something?
Well, she's in protective custody, so that's an extra layer there. I also wonder if, I know that when people are taken into custody and are transported, like somebody will pat down your hair if you're female and pat down your bun to make sure that there's nothing sharp or weird or drugs in there. And she was just interacting with her lawyers, and there's pens and, I don't know, paper clips, staples and stuff like that in the courtroom. And I mean, you'd be surprised at what they can turn into a weapon in the jail. So, and keep in mind, she's being transported back to Wakulla County too. So that's, I don't know. I think you probably have to consider her custody status in that as well. Oh yeah, was Harvey in the courtroom?
I don't think so. Didn't Joel or somebody mention that?
I don't know. The pool camera certainly didn't let you know. It may be that one of the other podcasters was there. I think Patty Playhouse said that she was going to go. So she would be one who would know the answer to that, I would suspect. But all we could see was the defense table and the dais and the judge.
Mm-hmm.
Yeah. I don't know why I thought that Harvey was not there, but Deep Dive True Crime also had someone who was physically there. So, yeah.
I was so busy focusing on the audio coming through Zoom because it was so crackly
It was bad.
Yeah, it was
was not-
terrible.
yeah, that was not fun.
Yeah. I was like so grateful when Georgia Capelman finally started talking because I could hear her. I could
Right.
barely hear Zellman and all that mumbling of the expert through Zoom. Could the denial of a change of venue be the ground for an appeal? Yeah. Well, that's what Charlie's using as one of his points for his appeal, right?
Right.
Right.
That is one of the grants. I mean, I just think that we're going to have an absolute circus on a 3850 on Charlie, because this is not the right point in time to bring up the Rashbaum conflict. And in fact, we're going to have some findings of facts probably at the trial court level. So it's probably going to be sent back for an evidentiary hearing. And that is going to be a day I take off to watch, because that is going to be juicy.
3850 under federal law or rules is what?
Oh, that's ineffective assistance of counsel in Florida.
but
So off the top of my
wouldn't
head, I can't tell you on the federal rules just because I don't.
Okay. Wouldn't that have to be done on post-conviction because it's not
Yes.
an error at trial? Yeah. So
Yes,
yeah,
that's what I mean. Is
I see.
the juicy stuff isn't going to be on appeal. It's going to be on post-conviction hearing that we have, where everybody, there's the airing of the grievances, as it were.
Yeah, and speaking of appeals, Katie, do you happen to know why it has taken the Court of Appeals so long to rule on Sigfredo Garcia's motion for post-conviction relief, as well as Katie McDaniel's appeal? I feel like it's been over a year. Is that typical?
So I have one client who is in custody, and it's on a relatively serious case. And the appeal is about a year old, and they're just about writing the reply brief, I think. I don't think it's in yet. I think they're writing it, the appellate team. So, I mean, that's about right. I would expect that we hear on my guy by middle of the fall, and he was convicted around the same time that those two would have gone up. Sigfredo, not so much though. Sigfredo's really quite some time.
Yeah, although his motion was probably about maybe a year or so ago.
Oh, really?
Yeah, where he's complaining about his lawyers.
Mm-hmm.
Yeah.
I think they did what they could.
Mm-hmm. Yeah, especially if what Sam Zangenhate said was that his hands were tied because his client did not want to point the finger at Katie.
Right.
Mm-hmm.
So he couldn't really do too much to defend him.
And I know Sam Zangenhate. Like we were both lawyers together in South Florida. He's a good lawyer, and I'm sure he made that record, even if it was at sidebar, to protect himself and to protect the case, frankly.
Yeah, he seemed to really insinuate that the Adelsons were the ones to be looked at. Yeah. Let's see, what about this? Something I can't get over is Donna Adelson's change in appearance from the airport to the courtroom. It's very dramatic. Yeah, we've all noticed it, right? Like everyone's like cracked jokes about Donna gaining a third of her body weight and just looking really different.
Well, she's not getting her hair done regularly. If she was getting Botox or filler, that certainly isn't happening anymore. She gained weight. I think what else? And, and she's
Gaining
not
weight
out
might
and about
vitiate
and
the
having
need for
fun.
fillers, though.
What?
Gaining weight might vitiate the need for fillers and Botox,
No,
though.
because the fillers push it up.
Oh.
Gravity pulls everything down. So gaining weight isn't going to help. You'll just have more weight being pulled down.
Mm. Okay, fair point.
Yeah, it's gravity. Gravity gets you.
Gravity gets all of us in the end, right?
Yeah, that's right.
Yeah, but as Hey Mona and I joked about in one of our comedic lives, perhaps Donna is deliberately gaining weight so she can look like this lovable, cuddly grandma instead of that stick-thin, svelte person that she was when she first got arrested. Yeah. Okay, what about this? Is there any chance that the contact between Donna and Harvey on her attorney's phone, or maybe it was the Apple Watch, we don't know, was actually Donna texting on the attorney's MacBook?
For those of you who aren't Apple people, you know that an iPhone will sync with your MacBook, and you can actually type into and an iPad too. So that's an interesting point.
Okay, but the attorneys are allowed to bring in MacBooks, right?
Yeah, you usually have to get it cleared, but frankly, there's so many. I mean, in this case, you got all these wiretaps that you have to go through with your client. And in more recent cases, we have body cam, so we really need the screen and the audio in order to go through the evidence with our clients. So that's what I use, and I've brought it into the jail multiple times to go through videos with clients.
So
I don't have to play on it though, because I have other clients' information in there. So that would be something where I would be slapping somebody's hand away.
Yeah. So is it okay for an attorney to let the client use their MacBook potentially to text?
I think that is a problem.
Okay. Because it's still communications with some potential conspirator.
Right. That's the problem. If that were to occur, and we're really operating in hypotheticals. But I mean, like I said, I've got so much privileged information on this computer that, I mean, if I saw another client trying to scroll through it, or even look at the names of some of my other clients, because some people hire defense attorneys, they haven't even been arrested. And maybe they think they're under investigation by some organization on a case that may not come to fruition for a while. I mean, even their names could be privileged at that point. I mean, I would, I'm not letting them run the computer. No.
Okay. Do either one of you want to address this? Like, why wouldn't Donna look for some kind of plea deal?
Want to do it, Katie? Otherwise, I will.
Because she's 1,000 years old.
Oh, don't say that. She's 75. 75 is the new 50. Yeah.
Not according to my mother, but yeah, I mean, because she's 75 years old, and I mean, how many years could she reasonably do in prison?
What could they give her?
Right, exactly.
Yeah.
And what would they get from her? Like, would they want her to give up Charlie and Wendi? So 2 out of her 3 children, and the other one of which she probably doesn't even count as her kid anymore. Well, and certainly tried to do something to him, we think.
Yeah, I think she's also way too narcissistic and brainwashed in her reality, just like Charlie, where, she really doesn't think she did anything wrong. So I don't think she would have her acknowledge that and just confess, especially with the grandkids. Yeah, like what would the Sunshines think of her?
The interesting thing to me was how stressed out Charlie seemed to be prior to his arrest, and how stressed out she was prior to the arrest. So that, kind of indicates to me that they know that they're not Teflon. Because otherwise you would just be chilling and living your life. So I don't know. I think that maybe it's possible this was a wake-up call. I just think that based on her age and what they would want from her, that there's nothing that.
Well, I don't know. You have had a lot of clients. I have never had a client, because the work that I did was
I envy
prosecution. There
you.
wasn't a lot of it, but I would have expected that most defendants would be pretty nervous. In fact, Sarah Yusuf's, the deposition that she gave said that when the arrests were made of Sigfredo and Luis Rivera and Katie, that I'm paraphrasing broadly, that Wendi was a nervous wreck
Right.
about it, because I mean it's pretty obvious that if you get them, then there's a pretty good chance that they're going to give up you. I mean, so.
Yeah, there's got to be at least some part of their brains that where they know that they're not untouchable.
Yeah.
Well,
And
one's been convicted, one's being tried, one
Is putting
is
her
sitting
assets in
out there.
trust.
Yeah, so of course they know they're not untouchable.
yeah, I think that's also why Donna was probably yelling in her jail cell. Did you guys see the True Lifestyles jail
Yeah.
records where, they said Donna was yelling,
At who?
probably to
yelling?
herself.
Oh.
Yeah, in her jail cell. Yeah, I think that must have been when she found out that Harvey was wiretapped. Just guessing, because it was sometime in April.
Mhm.
Yeah.
That might be true.
Yeah. Selman seemed so angry today. Fulford seemed nearly non-existent. Maybe they're regretting signing on to this. Katie, what do you think? Because don't you know both of them?
I don't know Jackie.
And-
She was on the bench and I think she left the bench in 16 and I moved here in 18 after doing about 9 years in Broward. I don't know. Josh is always very soft-spoken. He's usually not. He's usually pretty calm. Like he's not one of these guys that puts on a show if it's unnecessary, particularly if there's not a jury there. He's just not doing that. I will say that one of the old timers who helped raise me as an attorney taught me one fact that has stuck with me, and my husband's a lawyer too, and I repeat it to him all the time. You only regret the clients you take, not the ones you don't.
It's different from buying things. I always regret the things I didn't buy.
Really? But it's like, if something is telling you that this is a bad idea as you're talking to a client, it might be time to listen to that little voice in your head.
I thought if I were he, I would be unhappy about the podcasts and the criticisms of him that are being made. It's pretty hard to have it. Judy, you get those comments, just doing a podcast and doing a great job, not defending anybody or anything else. And I would think that's pretty hard for anybody to deal with. And there may well have been quite a few. So now he's talking about, the podcast, because a good part of his presentation was not the broadcast and the newspapers. It was the podcast and all the vitriol, I think, that he thought was being, directed at Donna. But he comes in for a fair amount of criticism, and it's never easy to hear the criticism. So I can certainly imagine him getting worked up over it, at least at this motion hearing.
Well, and I could also say that I think that he has children that are in high school and college aged. And as the child of a criminal defense attorney myself, I can say that, even pre-internet time frame, because this would have been like in the 90s, I definitely got some of that.
Yeah.
And I'm pleased to have kept my maiden name to keep my daughter out of that.
And of course, for him, it's generally speaking, it's worse for a parent to feel that your kids are being criticized unfairly. So, I can
I'm not
well
saying it
imagine
happened. I'm saying that they're the right age to be mining
but
for
it seems
things.
pretty understandable that when he's talking about those podcasts that he would get worked up over it.
Yeah. And I don't know that it happened, but I would, as the fellow child of a criminal defense attorney who definitely read things she shouldn't have, yeah, and it's painful to see your kid having an issue because of that. Only positive thing is his last name isn't Bokenschutz. It's a little bit less.
Yeah. Were both your parents lawyers?
Yes.
Oh, okay.
Yep.
Were
And my
both of
sister's a
them?
lawyer.
Oh, okay. So the whole family then.
Yeah, and we're impossible to deal with.
Everyone arguing over Thanksgiving dinner.
Yeah, and my brother's on a SWAT team, or was on a SWAT team, so it's just impossible to deal with any of us.
Okay. Well, actually, I don't think many people have been making fun of Zelman. I have heard people make fun of Fulford and say that her suits don't seem to fit, or she looked haggard, or something to that effect, or making fun of her funeral home business. But yeah, I don't think I personally have said anything really negative about Zelman because we hardly know him. What?
I have.
Oh, what? Oh, yeah. You said they didn't seem well prepared, or they can't write well.
Well, yes, and I think the way he makes arguments, I'm doing it again with him. The way he makes arguments is not persuasive. I mean, today, Judge Everett asked him about a 2022 Florida Supreme Court case on point, and he didn't know it, so he had to sit there and scan it. That's not being prepared to make a motion or stand up at a hearing.
Not when it's a Florida Supreme Court case.
Exactly.
I mean, there's, for the viewers that are not attorneys, there's like Florida law sup, there's unpublished opinions, there's, county court judges that sometimes write opinions that get tagged in Westlaw. There's always gonna be something you haven't read, but a Florida Supreme Court opinion shouldn't be one of those.
Right.
So what was the significance of that new case law?
Well, he was making the argument off a 1950 case that hasn't been cited by, and he kept saying it hasn't been overruled, but it hasn't been cited by anyway. And the cases since have not taken the position that that case took. And it's with regard to the change of venue and what you need to show. And part it was, I think, if I'm recalling it correctly, the question whether you have to try to sit the jury first. And he hadn't, he scanned the case while we saw him. I don't know if you watched the whole hearing, Judy, but he was scanning the case. We took a moment while he scanned the case. It's so that's my most recent example of where I get critical, but I've got a suitcase full of them. Now I'm exaggerating, a wallet full of them. So I'm guilty. I don't know if anybody else is, but I'm guilty.
That's okay. I mean, that's like a professional criticism.
That's right. I'm no personal attacks. No, but yeah.
Yeah. Well, yeah, I think that's a legitimate criticism. I definitely didn't pull the case myself while I was listening to it. I'll say that, but also I'm not on the case.
Mm-hmm.
This is a hard question. How would you all defend Donna against the bump? So I was thinking about this while you guys were talking. So I think I would still have her claim that she believed Charlie,
right?
That she was very concerned, but she didn't want to bother the police because the police have bigger fish to fry. So she didn't want to contact the police immediately because if it could just be some prankster trying to shake her down for money, then why waste a police officer's time by contacting them?
I'd say, look, I want to believe my son. I told my son I believed him about not being involved, but I know my son. And I did think that there was a significant possibility that he could have done something and not admitted to me about it. And here's the thing. Accessory after the fact is not applicable to immediate family members. So that is her best defense, because she can concede some points and kind of maintain her credibility and say, oh, I helped Charlie afterward because I wanted to believe him, but he's my baby. And I believe, and he's a perfect little angel, but we all know him. And, there's part of me that knows that maybe I shouldn't believe him. And then she can cry and, get the moms on the jury on her side. But that's the best defense, in my opinion.
What about you, Professor Potuto?
No, I agree. I don't happen to think it's very strong, but I think it's the best of bad defenses.
Well, yeah, I mean, I didn't say it was good. I said it was the best.
No, I know you
they
didn't.
had.
I know you didn't. She still has to deal with trying to flee the country. I suppose she can say, since she can't say there, that's the fact that she got on the stand at the bond hearing, because she can't now say,
I know that was a terrible idea.
oh my God. She can't now say, gee, I wasn't guilty, but along the same line you're talking about. But, my son got convicted and, I'm worried about it. Yeah. Because she said at the bond hearing, they were just going on vacation and they picked Vietnam because they might have to come back and they didn't want to be, if the police went after them or the FBI went after them, they didn't want to be held in some third-rate jail somewhere. The explanation she gave was just, I can't think of a worse
they wanted to
one.
be able to turn themselves in. Let me tell you something. We will find you. And we will get you, even if you run to a non-extradition country. The United States has ways to put pressure on these places, and they will.
Right. But her explanation at the bond hearing was just as I say, I don't know that I can think of one that would have been worse to use. And putting her on the stand and letting her do this, she's now nailed to this story.
Well, that was something that really confused me. It must have been her saying that or insisting on doing that.
Right.
And her lawyers must have tried to stop her. I had defendants who wanted bond all the time when I was a prosecutor, and defense attorneys who had good client control. Somebody with this kind of facts, a defense attorney with good client control would stop them.
Mm-hmm. That's fair. We will see. But that is fair.
Yeah. Also, as the part of the comedic improv comedy that Mona and I did, we said that if anyone asks her why she said this TV is about 5, then Donna can say, well, we were really talking about buying TVs beforehand. And so I was just excited that I had found out there was a sale on TVs, and we could say that Charlie and I just have ADHD, so that's why we blurt things out that don't seem like they have anything to do with each other. And we were really seriously talking about TVs before.
But this is why circumstantial cases can sometimes, everybody thinks circumstantial evidence is weak, and that's what people that are lay people think. Circumstantial cases can be some of the strongest cases you have as a prosecutor, because it's really hard to explain all of these little facts individually. If you have one eyewitness, it's really easy to discredit that eyewitness. They weren't wearing contact lenses, they have a bias, they have a motive, they're mentally ill, they were drunk, whatever you want to do. But these little, like the bricks that make up a circumstantial case, they're devastating.
Okay. Easy question. Is chewing tobacco allowed in Tallahassee court?
Somebody told me that Josh was tipping in the courtroom, and I don't think so. But I also was not inspecting his mouth.
I don't know what it looks like to do it. I saw a comment in one of the chats that said the claim was that he wasn't tipping the cup, so how could you drink it? There was somebody in the chat who, and I don't remember who it was, who said the cup was like had a straw in it, so he didn't have to tip it to drink it, because there either was a straw in it, which I didn't see, or maybe the lid had that little, that little straw top, and you don't have to tip then.
Or maybe it's really hot coffee and you're really only tipping it a little bit.
Right. But you can tell how boring many of us thought the expert was, that people started focusing on things like how he was drinking from the cup.
Yeah, I was like thinking like, boy, can this guy speak any more slowly? And the volume was terrible too. And it just seemed like he had a lot of just boring common sense stuff that he was saying. He was
Yeah.
just speaking in such general terms about how, look at all these whatever podcasts and there's a lot of stuff out there. Well, we don't know if people in Tallahassee were even tuning in. So that's what the judge was bringing out too.
And he was also non-responsive. And at first I thought he was doing it deliberately because some of the questions were not easy for him. And then I ended up thinking that he may just not be able to track the questions well enough, but he was frequently not answering the question, particularly from sometimes his own lawyer, but certainly with some of George's questions, he didn't seem to be, answering the question. You'd get, a lot of context, but it never got to what she was asking about.
Yeah, surely there's another expert that's out there, and surely there was testimony you could have watched of this. I mean, lawyers share expert witnesses all the time. We have like listservs where I say, who's a good ballistics witness that I can get on this attempted murder case, who can explain something like really elementary, break it down to a jury. And I would imagine that there was some tape of him testifying at some point in the past.
Tim Jansen thought he was the expert that they used in Idaho when the Kohlberger trial was moved, but that trial was moved for different reasons than his expert testimony, and so. But at least that seems to be that is a potential way that they found him.
And doesn't that town like at least triple in population when school's in during the school year?
Small. It's a small town.
It's tiny, and then the percentage of students.
Well, and the judge in that case said the security, the courtroom was small. They didn't have the security. They couldn't manage the crowds, which has nothing to do with we couldn't get an unbiased jury here.
Right.
And that was the major reason why that trial was moved. So.
And I mean, even from the defense end, like, I think if I recall correctly, Kohlberger went to court like in a bulletproof vest a couple of the first hearings because they were concerned somebody was going to try something. So, I mean, I think that, everyone would have been on board with significantly better security.
Right.
Yeah, can you imagine hordes of people trying to rush into the courthouse to watch Donna's trial or being up in arms if she isn't convicted? I mean, somehow people have better things to do mostly.
And just because a jurisdiction is larger doesn't mean the security is better. And we had a guy that was in the Broward jail, which is Fort Lauderdale, with Big County, for murder. And he and a couple of his little teenage friends tricked all of BSO and they escaped and they were gone for 4, 5, 6 days until they were caught. I mean, it was kind of impressive.
Oh, okay.
That happened in 2016, where guys escaped from the courtroom.
It's horrible. Well, I mean, how many deputies do you think they would have during Donna's trial in the courtroom in case like a fight breaks out or something happens during the trial?
Probably extra. But they're used to volatile situations in court. Family court in particular is incredibly volatile. Injunction court is incredibly volatile. I mean, I had a guy try to attack my client a couple of weeks ago in injunction court, and I was like, oh, it hasn't happened in a couple of years. But the deputies were on top of it. And usually they're watching everybody in the courtroom, but I just think a couple of extra ones. I think it's more of an issue that they're going to have more jurors in there and they may need more.
And that was what was the case for Kohlberg. They didn't have the room to be able to do it. I think Bundy,
you need 12 jurors and you probably need 10 alternates, right?
I think, Bundy, one of his escapes was from the courtroom. He went into the bathroom and then squeezed out of the window. I may have the facts wrong, but I think with something like that. But you
Yeah.
can't imagine Donna being able to jump from a second floor window and landing and be able to run off, or
Nope.
managing if she was able to do it. He lived on the rough for a while before they caught him.
And he was in his early 30s when he pulled that off too.
Yeah.
I mean, I can't imagine somebody Donna's age jumping that kind of distance and not ending up with a broken bone.
Yeah. I mean, and do those windows even open? I mean, can someone potentially open up a window on the 3rd floor of the courthouse and jump out?
No, none of these windows open.
Yeah.
And I don't know if they're hurricane glass, but I do know there was a movement to start replacing all of the windows in Florida with hurricane glass over the past about 15 years. And for those of you who have not grown up in or live in Florida, I mean, you could like throw an axe at a hurricane glass window and it'll bounce off. Like you might get a crack, but I can't tell you that we've done that in Leon because we're pretty fairly we're inland about 30 miles, but it's entirely possible they have. I don't know.
Okay. Well, this is interesting. Hi, Sandra, one of our trivia buffs here. She said that Zelman said today he doesn't agree with the way the conspiracy to commit murder charge is written. Sounds like at trial, the defense may argue that Donna would be guilty of obstruction at most.
Or accessory after the fact, which she can't be convicted of, most likely.
But that would be on the fact. Don't you, Kenny, in Florida, don't you just track the statute, or you've got standard ways of writing? And I can't imagine what they could have done with the conspiracy to commit murder charge. I mean, that's a typical charge, and typically you don't play with it.
Yeah, I mean, I'm pulling up the Florida has standard jury instructions on these
Yeah.
things, and so I'm pulling it up right now, trying to see. But he doesn't agree with the way that it's written in the indictment, was what he was saying.
Yeah, but that seems to me to be a particularly odd error if it happened. You do the indictment, you should, you're just going to track the language. You're not going to be adding or subtracting or being creative with it. Nobody would do that with a charge on the prosecution side. I mean, that's really a recipe for disaster. And these charges, aren't your charges? I mean, what happened, I was the principal drafter in Nebraska for the jury instructions in criminal cases. And after those were done, the Supreme Court reviewed them and vetted them. And then they were vetted as trials came, and there were appeals made. So to the extent they went through that process, and I'm assuming they did, I can't imagine what he'd be challenging, unless he's saying there's no evidence to support it.
Well,
But
then you
that's
can
not
do a sworn motion to dismiss.
Right,
But
right.
now I'm pulling up the indictment to see.
Yeah, I didn't
what
hear
it
that.
looks
I mean, but I had trouble hearing some of it, so I didn't hear him say that today.
Yeah, that did not really make it through to me because I was paying attention to the witness so much, but it was just difficult to hear him.
Same here. I don't recall him saying
I
that.
don't remember it.
Paying attention 100%.
Well, now I'm
or I
pulling it
couldn't
up.
hear it all.
Well, now we're going to get the, the good answer, because we're looking at the language of the indictment by somebody who recognizes how the indictment for this charge would be written. So we're in great shape.
Okay. The podcasts have hurt. Oh, go ahead.
It says that beginning in 2013 until October 1st of 2016, Donna Adelson in the county of Leon, state of Florida, did agree, conspire, combine, or confederate with Charles Adelson and or Catherine Magbanua and or other persons to commit first-degree murder, contrary to section, and then they have the conspiracy statute and the homicide statute. So, I mean, what do they think that?
The dates are wrong, or she didn't conspire, but it's an and or. So it doesn't say she had to have conspired with Katie.
Right. And or other persons.
By the way, I don't like
unknown.
and or. I don't like and or in law stuff, but it's an and or.
Mm-hmm.
They think that does he think the dates are wrong?
I don't know. I mean, what you could do is you could do a motion for statement of particulars if like maybe 2013 is too broad for you.
Mhm.
But in this kind of a case where you've got solicitation and conspiracy and you're not she would be a principal to the homicide, not the person that pulled the trigger. I mean, you're
Right.
not going to win this with an alibi. So that's
Right.
usually the kind of thing that you would be asking for a statement of particulars. And you could be like, aha, my guy was in Kentucky during the time frame that you've narrowed down. But here, I mean, you could have done this from anywhere in the world.
Right. Because she wasn't the shooter. Well, we'll have to see what he means by that.
Yeah, who knows? Maybe it was just some stray remark, but it's like, well, who cares? You know, that can be your opinion, but we're moving on. So, yeah. This is kind of an open-ended question for Donna's trial. What's something on the prosecution's list of, if this happens, we're in trouble? I don't think there's that. I would like to think that even if, let's say, if Katie Pickman were to
flip again,
to not testify or something happened to Katie, like they still have plenty of evidence against Donna. What else could potentially happen?
Yeah, it's the nature of a circumstantial case. Even if you manage to kick out one piece of evidence, the rest of it's still there.
Yeah, I don't know either. It can't be. I mean, the one person who could help her theoretically is Charlie by taking, the blame, but he's got an appeal, and if the appeal is successful, there'll be a new trial. So he's got a Fifth Amendment privilege not to testify, and all the reason in the world not to say anything that would have a negative impact should he get a new trial. And I can't imagine anybody else who can say anything that would help her.
One of their main witnesses dies. So here's the thing
possible. Death always is.
Yeah, death is always over all of our shoulders. However, if you're a witness in a case and you are subjected to cross-examination, you can read out their prior testimony. And you don't even need it to be this attorney's cross-examination. These witnesses have already testified. They were at Katie 1, Katie 2. And even if you said that Rashbaum's cross was ineffective because blah, 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 he was conflicted, you still have testimony from those first two cases. So I can't imagine that, even the death of a witness is really not going to be.
The lawyer doing the cross doesn't have to be the lawyer for the particular defendant who's being tried in the next case?
No. In fact, I have a case where, I have a really interesting case on preserving testimony where my victim was like somebody tried to chop her head off with a samurai sword and she overdosed before trial, but it was a domestic violence kind of a case. And so the defense calls her at the bond hearing and thinks that she's going to say, I love him. And they forgot that she's insane. So she said that in the hallway. I think I wasn't there. It wasn't my case at that point in time. It hadn't been transferred to me. But so she's insane. She may have said in the hallway, yes, I do love him. And then she took the stand and goes, oh my God, he's going to kill me again. And so she overdosed before the trial. So it was an unrelated death. But it turned out that was direct examination from the defense attorney. And the witness/victim was crossed by the state. And I could introduce it.
But it's still the same defendant in the both trials.
Yes, it was, but it's just the crucible of cross-examination.
We should do it. Of course, here they're co-conspirators, so
that would affect it.
That would affect. That's right. It would affect it anyway.
Yeah, but it was just wild facts in that case, and I was like, all right, nobody's ever done it. Let's try it.
That was a good question, because it forces you to think about what evidence that's in there that's so compelling. That if she could get rid of it, she'd be home free. And it's, and you've said this a number of times, Katie, it's a circumstantial case. So it's hard to identify, one piece that would be so critical. I mean, theoretically, although it's not even theoretical. I was going to say, Judge Everett could say that the evidence about Vietnam is not consciousness of guilt, but that's impossible because he said at the bond hearing, clearly it was consciousness of guilt. So he would have to reverse himself.
And Donna's prior testimony could be played too, where she's like, oh, I was just going on vacay.
Oh, I know. It's terrible. Yeah.
Yeah. I don't understand. I don't
either.
What if Donna declines mentally? Well, they can still try her, right?
So there's a couple of different standards in the state of Florida. There's competence to stand trial, and then there's competence to represent yourself, which is it's a higher standard. Competence to stand, or your competence to stand trial for somebody that has, graduated from high school, reads and writes the English language well, and does not have a major mental health disorder. And we don't think she does. So her mental decline would probably be some kind of like dementia related something. I just, the standard is so low. You have to know the prosecutor's against you, that your defense attorney is going to help you, that the judge is the umpire, and you have to be able to manifest appropriate courtroom behavior, which actually might be her big hurdle.
Yeah, but that's not going to save her from being prosecuted anyway. There are tons of people with low IQ and mental problems who are convicted.
No, I mean, if she declines to the extent that she drops below that standard, she could be, potentially involuntarily hospitalized.
Yeah. But it would have to happen in the next, between now and August 19th.
Yeah.
Because nobody's making a claim about that today.
Yeah, and I don't think so. I don't think that she would ever drop below that standard.
Right.
Okay.
And she's been cooperating for everything we know. She's been cooperating in the defense so far. She was engaged at counsel table today. I thought
Right.
she sat there quiet with, no expression a lot of the time, but not all the time, as I recall.
Mm-hmm.
Okay. So has Charlie's appeal deadline been extended? Well, they enlarged his, they gave him a new deadline to file
to write a new brief, a bigger brief. And they also, I think where the extra time is, they gave the state more time to file the answer brief, which they'd have to do if there's going to be a large brief coming in. The state has the right to see it. So I think if there are delays now after that enlarged brief is filed, and I think it's 2-3 weeks from now. Judy, do you remember?
Yeah,
I think it's coming
late
up.
June. Yeah.
Yeah.
Sometime end of June.
Now it would be the state saying, now we don't have enough time. I mean, we've got a right to be able to do our best job also. And we don't know, we didn't know exactly what's going to be in here, but that's not going to be, those are not, I know every delay is a delay and it pushes back decisions. I understand that, but that wouldn't be, a big delay.
Yeah, so let's not cover Charlie's appellate brief then, since his attorneys could be watching to get ideas. And yeah, because when I saw that, I was like, great, now he has more time to cook up things to address whatever Professor Potuto mentioned in the live stream. Yeah.
He can't cook up anything. The lawyers can't help him do. Plus, he's tied to to the transcript at trial. I mean, if he wants to say something new now, he's going to have to do it on post-conviction, and he's still going to have to explain, why it wasn't raised earlier. And typically the only way you can get that done is by saying is by saying your trial lawyer was ineffective and didn't represent you adequately.
Which is why
otherwise
I can't wait
it's
for
a
that.
otherwise it's a tactical decision that a lawyer made, and there's a range of things that lawyers do, and you don't know. You can't, most of the time you don't know with 100% certainty. You're making a calculated judgment about whether something is going to work or not, or whether this is the best argument there. So those are hard. Those ineffective assistance of counsel claims, independent of a real conflict,
Right.
are very hard to show, because you have to show not only that the lawyer didn't meet the standard of a reasonably competent lawyer in the community, but then you have to show there was actual prejudice, which means you have to be able to demonstrate that there's a reasonable likelihood that the jury decision would have been different had the lawyer done his or her job. And that's a high standard when there's enough other evidence. And he took the stand, which makes it even harder, because the jury's entitled to assess credibility and say, we just don't believe you.
Well, the hearing where Rashbaum testifies and potentially Harvey testifies, and there's this, an airing of the grievances. I cannot wait for that because that's going to be messy.
So you as a defense lawyer can't wait to see a client turning on a defense lawyer?
Because it's not my case.
Of course.
That's why.
That's right.
I mean, if it was me, I'd be puking in an airsick bag. As a spectator, I'll enjoy it.
I take a perverse pleasure in watching some of these things too. That's what I call it. It's perverse pleasure.
I think that my people, the Germans, call it Schadenfreude.
Ah,
Yeah.
that's a nice way to put it. I say perverse. I'm willing to stand up and say it's perverse. I mean,
Yeah. Pleasure at the misfortune of others. That is
that's
German.
right. And we don't say there, but the grace of God go I. We say, isn't this great?
Oh yeah. No, it's, hand me the popcorn.
Yeah, that's right.
Okay. So, Sandra said Zelman said today that the conspiracy ended when the murder.
That I heard.
Okay, which might be insight. So you think he's going to argue that Donna had nothing to do with it until after the murder and she was helping Charlie?
No,
cover
I
him
think
up?
he's going to argue that once the murder took place, you can't use co-conspirator as a way to get in evidence after that date, so that any evidence that's after that date does not come in on a co-conspirator exception. That's what I think the argument is going to be. And maybe that's what his complaint is about the conspiracy charge. The
Right.
date goes past the date of the murder.
That's an interesting.
Sarah, that's a great question. Yeah.
Yeah, that's a really.
Sandra,
Now
sorry,
I'm
Sandra.
pulling up Westlaw now.
Yeah. No, it has it to the extent you're engaged in a cover up, you're
Right.
still I mean, I think that's textbook law that the
I
conspiracy
think
is
so
still
too, but
going
now
on.
I'm wondering, if that's going to be their position. Surely they're standing on something, right?
A 1950 case that has been cited in 70 years.
Okay.
75 years.
Potentially.
Okay. Well, this is an easy question. No, the witness lists haven't come out yet. I feel like they came out just a few weeks before Charlie's trial.
I don't remember the date that Judge Everett set for when, the discovery has to be complete and the witness lists have to be turned over or submitted.
Okay. But it hasn't been any time. I mean, it's not coming up soon. Yeah.
I don't remember.
Yeah. What about arresting Harvey has become a moot point? I don't think he looks like death warmed over. I mean, he's almost 81. So, I mean, how spry and youthful do you expect him to look? But, I mean, if they have enough evidence of some crime, I would think that the prosecution would still arrest him.
I'm trying to think whether I think he looked like death warmed over.
I don't think he looked like death warmed over.
I mean, when we saw him, he's sitting at a hearing with the woman he'd been married to for how many years? 50 years, 60 years, who's been sitting in prison or in jail for almost a year now. I'm going to get my numbers right. He's got another son that he doesn't talk to, and another son who's been sitting in prison for a couple of years. And now he's at a hearing in which she's not granted bond. I mean, I think anybody might look pretty terrible at any age with, all that on you when you're showing up. I think he was a little hunched over. I mean, he wasn't, he couldn't have jumped out of a second floor window at a courtroom, but I thought he looked okay.
Okay, here's a picture of him. Let's see. There he is.
Aw.
That looks okay to me.
Yeah, he looks okay for 80.
He doesn't have a
almost 80.
nurse sitting next to him.
Yeah. Well, there was supposedly maybe Janice was with him, Charlie's last ex-girlfriend.
Well, she's not sitting with him because you can see that at least
Mhm.
a fair amount of that bench has no one there.
Yeah. Okay, so he looks arrestable. You know, I still say if he committed a crime, he should not get away with it just because he's almost 81.
Oh, I agree.
I just think they don't have as much evidence against Harvey because Donna talked for them both.
Yeah.
Yeah, she and Charlie just couldn't stop talking.
Yammering.
Yeah. Okay, let's see. Okay, Rochelle doesn't think they'll go after Harvey. Yeah, we want Wendi to be next. I think most people.
And Wendy's the most clever one of all of them.
Yep.
I agree.
Yeah.
Whether
Although
it's the
she's
legal
done
training
some-
or just not
Yeah.
being a moron.
But she's done some strange things too. The day of the murder, driving out
the
of her
drive.
way to the house and giving what 2 or 3 different stories about it. The day of the murder, when the next day, you know, a nervous wreck, and this is what Sarah Youssef reported, that she kept saying they're going to arrest me, they're going to spend the rest of my life in prison. The day that that Garcia and Rivera are arrested, saying, you know, they're going to think my brother did it, and she's off again. She's been a lot better than Donna, but
Oh,
boy,
yeah.
that's not a very high standard because Donna is very chatty.
Well, but it also takes a lot to be able to tell your mom, no, we're not discussing this when that's your mother.
That's true.
And
That's true.
she has been standing pretty firm on that and has had a separate attorney the entire time, which is
That's true.
possibly the most intelligent thing she's done.
Yeah. I agree.
Yeah. Don't forget that text that Donna sent to Wendi saying, like, everybody's looking to protect you.
Yeah.
Or-
Hey, look at what Chewy Boy has said. The same argument was, I don't remember this, but was made in Katie's trial. Conspiracy ended after murder, and the judge ruled against them. It's not typically, you know, a conspiracy doesn't end the moment the crime happened, because people who are in a conspiracy not only work together to plan the murder, but they work together about, that's right. I mean,
And the
otherwise,
statute says in furtherance of the crime. So getting
Exactly.
away with it is part of it.
Yep. Okay. So, hi, New York Patriot lady. She says, wonder if Tamara will be part of Donna's hearing. I don't think so. I don't think she really had a lot of incriminating things to say about Donna. So that was Dan's friend. You can see her police interview on Deep
Yeah.
Dive True Crime. He recently premiered that again. Yeah. But she said that Donna acted normal that day after Dan was
Did
shot.
she?
Yeah, she just
don't know.
decided to go over to Wendy's home, and Donna was there, you know, just acting normal. And the only weird thing that Tamara said regarding Donna was that at Dan's memorial service, Donna was walking by with one of the children, and Ruth Markel asked if she could
Right.
schedule a time to see the children because she would really like to see them again. And Donna totally ignored her and kept walking. So Ruth Markel said to Tamara something like, I hope what I just heard didn't really happen, or something like that. Yeah.
As I recall, I didn't see the redo that played, but as I recall, she had more pointed comments about Harvey's behavior.
Right.
Yeah. So, and I think she would be a really credible witness because I listened to that interview, and she seemed to me to be very, very believable.
Mm-hmm. I agree with that. There's also another witness that I think that we haven't heard anything about that I think we may hear more about, and that's Ryan Cox. And Deep Dive True Crime put
Oh,
up
yeah.
her interview.
Yeah, she's a lawyer. Do you happen to know her?
I actually know her. She used to be a public defender at Broward when both my husband and I were prosecutors down there, so we know her. And then we both moved up here as well. So, but yeah, she was saying that Wendi was dropping off clothes at her house. You know, I guess her son was a year or two younger than Wendy's boys. So she was getting the hand-me-downs.
Well, Sarah Yusuf's, the written deposition, I think, I mean, I don't know how she would appear in person, but the written deposition it makes me think she'd be a really good witness. But most of her information, or almost all of it, runs to Wendi, not Donna. And that's the same thing with Ryan. It's running to Wendi, not Donna.
But if her house is getting cleaned out of stuff and she's getting rid of things to move, that might be Donna
You're
little
right.
bit more, because there's no way Donna wasn't helping her move stuff.
Well, I still think, and who knows whether they've done it or not, that were I doing this, I would have checked to see whether anyone researched or called moving companies or was looking for places to live, because, you know, Donna was a planner. I mean, look at those, I don't know what you call them, day books, whatever they had with all planner.
Big notebook.
So,
or shipping things to Miami.
Yeah, it's a little hard for me to believe that if they were, you know, they were going to leave that day, that she hadn't done some, you know, planning ahead of time, and that there might not be a trail there. And who knows? I mean, we'll know when the trial's over whether they found anything, but I hope they looked.
Yeah, and maybe there's credit card receipts from Pac Mail or UPS store or whatever, where you could ship it and not have to hire a moving company.
Exactly. I hope they looked, because she just doesn't strike me as someone who would wait to the day and then worry about it. Not from those, I mean, those ledger, I don't know what to call them, but whatever they are, they were amazing. Which is why, again, now that I'm remembering them, you know, this claim that I'm the poor mom who, you know, sort of believed my son and I went along with it. Those ledgers can show a very different person than that person.
Yeah, I think we know who the real maestro is looking at those planners.
Yeah, and
I also think
planner.
it's a generational thing that, you know, my mother keeps lists like that, and she and Donna are almost exactly the same age. But like, you know, detailed lists of steps and things like that. And she'd be like, you know, 100% my mother would be in prison if she tried to pull something like this off.
Well, I said, watching these trials and with the, you know, stuff they can do to track cell phones and the ring cameras and the other cameras and everything, I thought, gee, I once thought that I could pull off the perfect crime, but I couldn't possibly do it today, with the possible exception of poison. And I have to think about poison a little, whether you could, you know, manage to acquire it, and, you know, because that wouldn't show up on a ring camera or anything else. I mean, you could put it in a box of cookies or something.
Joe, do you often think about whether you could pull off a homicide?
Yes,
I do
because
too.
because I like mystery stories.
I think it's the nature of the work. And
and
doesn't say anything about us personally.
I could do this better than they're doing it.
Yeah. Well, once again, as Kathy from Gossip Room, her innuendo says, she says, well, these people are a bunch of true crime idiots, but thanks for giving us more stuff to laugh about, or
well, you know, in
keep
part,
screwing up.
Yeah, but in part, the people who get caught tend to be the ones who are not as clever.
Yeah, I used to tell juries that all the time. We don't catch the smart ones.
Yeah, I mean, you do once in a while because something screws up, but you catch the, you know, but it's amazing to me how I'm going to say unsmart they are. I mean, yeah, it isn't simply you forget to do one thing or you make a mistake here. It's, you know, it's massive not doing the crime right. I should give lessons in it. Here's how you should go about it.
And my husband keeps saying that, like, most men think about whether, you know, they really have it in them to commit a murder. And I was like, oh, I think about that several times a week. And now I'm going to be able to report to him that you do too.
I see, Judy, you you got two guests who are potential murderers here. I bet you didn't know that when you asked us.
No, it's very interesting because Professor Potuto, when you talk about poison,
It's
how
I
would you?
keep telling you it's Joe, and you won't do it.
Oh, okay, Joe. Okay, thank you. Well,
You're welcome.
how would you get the poison though? Because everybody
Well,
uses
I'd have to
credit
think
card.
about this, but I will tell you that I have a 15-year-old niece who's taking chemistry classes now, and I put her on that question. I said, you're going to learn about, chemical compositions and these sorts of things. Ask some questions about poison. Actually, you don't even need poison, but see, then you're into the problem of the cameras and everything else, because you could just
Air
inject
embolism.
air and
Yeah.
you got it. But that now we're back to the camera's going to show you going, the camera's going to show you, so we're
And you'll
back
still
to
have a
that problem.
pinprick that might show up
Yeah,
in the autopsy too.
yeah. But they wouldn't know I did it. The problem is the cameras are going to, and I would have to buy the hypodermic somewhere, and yeah.
And potentially, I mean, like there's cell phone evidence, there's all kinds of GPS.
But I could not use, I mean, that I could do. I could not use the cell phone. And I know very well I could get rid of a weapon. I would go out into the middle of the ocean and drop it. How
Oh, hell
many,
yes.
you know,
Salt
so I
water,
could do
rust
that.
it
But
up.
now they're tracking you with everything. So, I mean, there was a time, I passed the time where I could have done this easily, perfectly. It's a
I do
shame.
have an idea for you, which is I do recommend like a Hobie fishing kayak, because you don't need a boat, you don't need GPS, and you take that off the coast,
But
dump it.
they'd know I bought it or rented it. There'd be a trail. There'd
You
be a
need to, well,
trail.
there needs to be something where you bought it off Craigslist from somebody who seems to be,
What?
well, then I guess there's a trail on
There's a
Craigslist.
trail. There's a trail. See, I've thought about all the ways you've gotta just, take off your list as ways to do it.
Maybe we could hollow out a tree and make a canoe.
I don't think I could, I haven't been in a canoe in years, and when I was in a canoe the last time, I dropped the oar in the water when we were in sort of the middle of the lake, and then I had to be rescued.
Okay,
Because there
so
was
I'll do
no
this
oar.
alone.
Okay. So there are free needle clinics where you can get your needles, but I
Yeah.
don't
And
know
they
if
don't
they
take,
have one.
are you anonymous when you go into a needle clinic? So they don't take any kind of camera or anything? There's no
I think
record of
it's
who's
needle
getting the needle?
exchange.
What?
You need to find a diabetic and just steal it.
That's a good idea.
Mhm.
Yeah. Okay.
Okay. Poisonous. Yeah, just like that lady with the poisonous mushrooms. Yeah.
Yeah, well, I wouldn't know poisonous mushroom if mushrooms to me are mushrooms. So I'd give them, mushrooms that are not poisonous, and then I'd be disappointed because nothing happened.
They might have had a great trip.
Sorry.
Yeah. Oh, okay. So Chewy Boy is saying Zelman is listening for defense tips. Well,
You
maybe
didn't get
they,
any from me in the last 10 minutes.
yeah. Yeah. Let's see. There were actually some questions up a while back. So let me scroll through. Feel free to make other comments while I'm looking for questions.
Well, there's a sufficient number of piers, Joe. So what you could do is you could take it off the end of a pier, maybe a caravelle, where we've got some really dark water, a lot of mud.
But I'd
and
still have to get it. You keep jumping the point where I have to find the boat or the canoe or whatever at first.
No,
And that's what I
no.
think.
I'm saying you just go to the end of the pier and chuck it. You don't need a boat.
Okay. Yeah, but is it deep enough there?
It could float
Not
back.
only is it deep enough, it's probably a good 30 feet deep, so that's good enough. But we've got mud on the bottom, so then you got
Yeah, so it'd
silt
sink,
and
yeah.
silt and silt, and it's at the mouth of a river. So,
Okay.
so
But
that's how we're
they
going to do
still
it.
might be able to track me driving there. But of course, they wouldn't know if they can't find it. You're right. Maybe that's it. I'll have to think about
Yeah, and we
this.
just get a ghost gun.
Mhm. Well, I can't. When I was in the prosecutor's office, I went under the shooting range, and I thought, I've watched all these police procedurals and westerns, and this would be easy.
Mm-mm.
Couldn't shoot the gun worth the thing. They gave me a shotgun, and I had trouble with the shotgun hitting
Ooh,
anything, which is
that is
really
bad.
kind of
All right. So am I carrying out this whole homicide we planned, and you're just going to pull the strings?
That's that. Yeah, see, that's right. That's the way it should be done. You go do it, and I will be the mastermind behind the scenes.
Okay.
And then
Well-
you'll just,
Yeah. Well, we do know from this case that you shouldn't have an accomplice with you, because the whole plan got screwed up because Sigfredo went rogue and asked his childhood friend, Luis Rivera, to come along with him. So I don't think Charlie expected Luis
Yeah.
Rivera to be tagging along.
Which always was a question that I had, why he would do that. I mean, it sounds as though he just thought he was going to party in Tallahassee and wanted a friend along to party. He didn't need somebody to drive the car.
I wonder how much cocaine he would have done without Luis there.
You think he'd do more?
I feel like he'd do more, because sometimes like a friend is a moderating.
Really? I wouldn't know this personally, but I always thought it would be more of a party, more convivial to be doing with someone else. But I have no experience, so I don't know whether that's true.
Yeah, my polygraph was very boring when I took one.
Yeah, this Northwest, this one I do know. I do remember.
Yeah.
It was, and I thought the judge had a really good question there about whether the lawyer could sign as a witness on the affidavit.
Well, you couldn't find one other person to sign an affidavit?
Yeah, it's hard to believe, isn't it?
I mean, surely there's an investigator or a secretary in the office. Right?
I would think. Oh, there are two lawyers on the case. Did they both sign? Is that where the second signature? No, couldn't have been, because the
No.
judge was talking about Zellman in
That's Zellman
particular.
specifically.
Yeah,
But I mean, like, don't you have an intern?
yeah.
What affidavits are we talking
In support of moving the trial?
Right.
As far as I think the affidavit cited the news coverage. We just got a news alert.
Oh, about what?
Oh, it was a weather alert. Sorry.
Oh, it's too
I thought it
bad.
was maybe a
Yeah,
Donna
Donna?
alert.
What? Okay, I'm curious if we're seeing an unprecedented amount of appellate preparation in these hearings, or is this pretty standard?
Standard in a first-degree murder.
Mhm.
And by the way, even more pronounced when death is on the table. If it's a death penalty case, it's a bifurcated trial. So the first half of the trial is the guilt or innocence phase. And then you have a totally separate team of lawyers that are always preparing for the mitigation for the death phase, in case you go to that. So the ass covering is legion.
Right.
Okay. Anyone know where and what Wendi is up to? Well, just from what we've heard, she's somewhere around Austin, Texas. And she doesn't seem to be working, as far as I know. There's nothing online.
Yeah, I don't know.
How old are the boys now? I think
14 and 15.
I thought one of them just had a birthday. Are you sure it's 14, 15 and not 15?
The birthday is
16?
in July.
Oh, okay.
Okay, because
Yeah.
it was 2 weeks after his father's death.
Yeah.
Yeah.
So, so we forgot to mention that supposedly didn't Harvey Adelson, or at least Donna and Harvey, might have gotten a condo for Wendi back in May or something before Dan was killed. Or at least they signed a lease for a place.
I don't know what school the boys went to down in Miami. I venture to say it's private, and think about what you might need to do to get them in a private school. So I don't know if they maybe went to public school for a year, or if there's something where somebody was inquiring about the school. They'll always have the defense that, we thought Wendi was going to win that relocation
win the case,
motion.
yeah.
Right. And that we wanted to show that the schools in Miami are much better than they are in Tallahassee, which I can tell you for a fact they are not. At least the public schools are not. But that'll be interesting to see. And keep in mind that if it's a private school in Miami, they may have some high profile type people. So they may be really keeping track of communications with the office and who called when, and, keeping the kinds of records that other schools might not keep.
Another set of records I hope they checked out.
Yeah. Oh, okay. Yeah, she did have a real job because she had the clinical
At the law school.
professor. Yeah, the medical legal clinic, something or the other at Florida State, and then she was a clerk for that federal court judge,
That was
Judge
a real job.
Diaz. Yeah.
But Joe, I'm going to show my ignorance here. Like when she was saying that like she only needed to be at the school like 2 hours a week, that seems like a really low case.
I didn't hear her say that, but it particularly for clinical. I mean, if you were a classroom instructor, theoretically, you could go in and do the class and go home. I don't know anybody who did that, and I never did. I was at school all the time. But for a clinician, unless she's saying that she would be at school, but then she would be at court or somewhere else supervising the students. But she couldn't have just been doing 2 hours. I mean, you couldn't.
Maybe that was over the summer, though.
Yeah, even during the summer, you can't.
You
I mean, you can't effectively supervise students who are going to be interacting with clients by only doing 2 hours a day. I mean, I think you could risk ending up with, an issue with regard to your professional oversight, because if they're dealing with clients, I mean, you got to be paying attention. So 2 hours, I didn't hear her say that though, so I can't really.
I don't know where I heard that. It just
I think it was Lacasse. Yeah,
Huh?
I'm pretty sure it was Jeff Lacasse that mentioned that during his police interview. So maybe he was just exaggerating, just talking off the top
Well,
of
and
his
if they
head.
doesn't
don't
really
do
seem like
if they didn't do the clinic during the summer, I mean, there's some clinics, maybe most of them, if the clinical professor, and she was not on a tenure track, so it wouldn't apply to her, but if the clinical instructor had a publication obligation, because of the intensity and the number of hours when you're doing clinical and supervising students, they often are given release time in the summer because the courts are slower or maybe not even in session some places to be able to get that work done. Or to get, the clinical manuals updated and all those sorts of things that would be difficult during the year to do because they're going to have high intensity so that's possible, but not 2 hours a day. Maybe it could be if she was but school 2 hours a day and then at home on her computer if she was doing writing or whatever, that's possible. But I'd have to hear what exactly what exactly her role was, what they were doing at the time. And what exactly he said.
Okay.
Yeah, maybe I'll go listen to it again and figure out what he said.
Yeah.
It seemed very low to me, but it was also the summer, so.
Yeah,
it's possible. But she was not on a 10-year line, so she shouldn't have had any publication obligation. That triggers if you're going to be, if you're on a tenure track, you typically have some publication obligation. And she was
But
not.
she was writing something. She did have
She might have been doing it on her own, but law schools don't typically give you release time. I mean, if I want to write a mystery story, law schools don't typically give you release time to write something. You get release time if you got an obligation to do something at the school and it's part of your job responsibility to do it. And then you can make the claim that you're too busy, so you've got to have the time. This doesn't sound like it. But I don't know exactly what her status was or what she was writing. And she was writing, I mean, she wanted to be doing representation, I think, and not simply the clinic.
Her little article was part of her little alibi that she had emailed that to the law library for the citations or something like that.
Yeah.
Yeah. Well, who knows if it got published anywhere. Could have been like a magazine article, like a bar journal article,
or self-published like her book.
Yeah. Well,
self-published.
Katie, do you know anything about South Point Elementary? Because Clarissa says that's where the children first went.
I don't, but I'm assuming that's because it's in South Beach, and it's a public school in South Beach. But I can tell you that, like any place that relies on property taxes for education, the higher net worth properties are obviously going to have a better elementary school, and South Beach is one of the highest priced places you can live in Florida.
Wendy's living off of her kids' money, down left. Wow, her rent is $6,500 a month. Wow. Well, I wonder how someone
In
figured that out.
Texas, in Austin, Texas, that
That
sounds
sounds
I thought that
odd.
her
really
condo
high.
was renting for $5,000 a month, the one in Miami.
I think
Yeah.
in Miami, because I thought that she's now sold the condo that she had in, I thought she sold the condo in Miami. No, maybe it's just been on the market forever.
Yeah, I think it's still being rented.
Yeah.
Maybe. Yeah. Not sure. But okay, did he mean she worked at home? Yeah, who knows?
That's what we
but
don't know.
That's
Yeah, that's what we
entirely
don't know.
possible because she said she was working on the article at home.
But again, that would mean that the clinic was not, she had no clinical responsibility in the summer. Otherwise, you couldn't do 2 hours. 2 hours is just not enough to do student supervision.
Mhm.
Okay. Yeah. That's funny. I have no idea because it turns out FSU actually gave the freshman incoming students
Yeah,
copies of Wendy's book. So
Yeah,
they
there
didn't
were
even pay for it.
yeah, there were a couple that schools are not doing it anymore to my knowledge, but there were a few years where they were assigning the entire incoming freshman class a particular book to read, and then they would break them down into small groups with a faculty member uh, moderating the conversation. It was intended to be a way to sort of get these students acclimated to the campus, get to know some other students. They're not doing it anymore, but that's what happened to that book. And I think Dan helped her get the school to take that book. But the school would have bought the book. So there would have been a purchase, even though they're giving it to the students for free. It's unlikely they got well, it's not impossible actually, since she did a private publishing, that she might have just handed it to them to use, but typically you still have to buy the book. The school would.
Okay. Yeah. Why on earth would she not have reported that had the student who allegedly kissed her on the mouth that had the student removed? That's true because Professor, have you had anyone put the moves on you when you were a professor?
Oh, I
And
guess.
would you report the student? I think you would.
I don't know. I don't know. It would depend on the circumstances, because it would be a big deal for the student. And it doesn't sound like, assuming it happened, it doesn't sound like an assault. It might have been unwelcome, but it didn't sound like it was an assault or anything major. So, I don't know what I would have done. It didn't happen, so I'd have to sort of guess what I would do. But she thought the what is it, the salesperson, the young person at the liquor store, she told him about her beautiful blue eyes, so she's flirting there with someone who's seems to, from her story, sounds to be considerably younger.
Yeah, I don't recall if she said the person was young, but it could just be some more made up stories to flatter her ego.
Or he asked for her ID
Oh,
and she said, "I'm old as dirt. Here you go." So maybe
okay.
that's the.
And
I want people to card me.
Didn't she tell that story during the
To the
interview?
detective.
Yeah, to the detective, yeah.
Yeah.
Which seems such an odd thing to be telling a detective when your ex-husband has been murdered and they're starting an investigation as to what occurred. It seems to me to be an odd thing to tell a detective anyway, but on that day, in that context, it's really odd.
Yeah. It was kind of like diarrhea of the mouth almost.
Well, she comes by it naturally, right?
Yeah, just like Charlie and Donna. Yeah. Okay. Okay, great. Well, do you guys have any closing remarks? Because it's almost 2 hours, and I don't know if you saw that negative comment from some guy that said we were just talking on, and we need to wrap things up because he has better things to do. Something to that
Doesn't he have agency? You just turn it off and do something else.
Turn it off. We're not forcing people to listen. It's like, don't you ladies, this is all nice and lovely conversation, but I got better things to do and you're wasting my time.
Well, hopefully our little murder class was good enough for that guy.
Yeah, how hard it is. It is really hard to commit murder these days and get away with it.
That's right.
Yeah.
I guess the only thing I would say is I still think this trial is going to go on August 19th.
I think so.
I think you would have to have a really act of God, which I'm afraid to put it out there. It is hurricane season. So I could, it would have to be something like that would delay this trial.
Well, if the courthouse, if the wind was so hard that the courthouse came down, then they would get their change of venue.
Fair. That actually happened in Panama City because their courthouse is right on the Gulf. You look out the window and you can see a marina. Oh. And that courthouse was unusable after Michael hit. And in fact, all of us as prosecutors in this circuit got sworn in to that circuit so that we could cover things.
Wow.
Yeah, I see.
But we're so far inland, I really don't think that would happen.
Mm-hmm.
Okay. Yeah. So fingers crossed. There probably will be some other motion hearing coming up.
Seems
who knows
so,
when?
yeah.
A couple of weeks, a few weeks, and
well, he hasn't filed the motion yet, so
yeah, he said he was going to do it next week.
Yeah, he said hopefully, or he planned to, or it wasn't an affirmative "I will." It was a little hedging. Yeah.
Okay. Yeah. So I think we answered that. We think it's still going to happen August 19th. Yeah. Okay. Well, thank you guys so much. I'm sorry I'm kind of wilting here because I haven't had dinner yet and I'm starving and stuff. But really appreciate you guys joining in, especially Katie, you jumping in on such last minute notice. So
happy to do it.
You're one viewer who has better things to do but can't exercise agency and do it himself. Notwithstanding, I enjoyed it very much. So thank you. Both of
okay.
you.
Yeah. Thank you guys. Have a great weekend. And hey, Mona and I will come back with some comedy on Monday night, unless we have to change the time. But so far it's scheduled for Monday night. So
you want to tell us what the subject is going to be, or it's a big secret?
No, it'll be a surprise. Yeah.
All right.
Do you have an outfit?
Don't think comedy is appropriate, then obviously don't tune in because we don't want to see the sourpuss comments from people getting mad at us. It's like, how dare you make
have an
me watch
outfit
this?
for it? Have you acquired an outfit?
Yeah, there will be outfits.
Good.
So we've done some advanced planning. Yeah. Okay. Well, have a great weekend then, you guys. Thank you so much.
You too. Bye.
And
have a good weekend.
Thank you.